Thank you, my Lord. Lord,
I don't know how big your debt is, but your debt is quite big.
Sorry, my Lord.
I said, I don't know how big your debt is.
Yes, my Lord.
But your debt to your colleagues is quite big.
Yes, my Lord. I'm indebted to their kindness.
Yeah.
Especially our ever objecting colleagues from the state. It seems like they are very cooperative at last, and I appreciate that, my Lord. But thank you, my Lord. I'm saying that in jest, my Lord. I also owe the debt of gratitude to the court for affording me the opportunity.
But it's more your colleagues than the court.
Yes, my Lord, my colleagues, but especially the court, my Lord.
Yeah, okay.
Yes. My Lord, we have prepared the heads of arguments. They are largely quite determinative of the ambit and extent of our case in this matter. By way of introduction, my Lord, as we start, we point out that this is an application for bail, pending the final determination of the main criminal hearing, which is still yet to come to the courts. At the onset, my Lord, we put forward the following. The applicant seeks to be admitted to bail on the conditions, and my Lord, you may not need to write them, they are set out in paragraph 2.1 of our heads.
Okay, you are not reading your heads, eh?
I'm not reading, my Lord, but they will guide me as I make submissions.
Okay. All right.
The conditions are set out, and it's important that I repeat them, my Lord, and I'll tell you why once I'm done. He seeks to be ordered to report himself to Ochomoise Police Station every Monday, Friday, between the hours 7 to 7 in the evening. You can rest assured, my Lord, that there was no evidence that was brought before you by anyone, including the state, that this requirement is unreasonable, inadequate, or will not meet the purpose for which it is intended to. So His Lordship can accept that this is uncontested. The second condition that he goes to is that he be ordered not to leave the district of Windhoek without the prior knowledge of the investigating officer or any designated police officer. There is also no controverting testimony that this will be inadequate or it will not be reasonable. So His Lordship can accept that. And the same goes for all the others, my Lord, including the surrender of the passport, the order that he should not interfere with the police investigations or with the state witnesses in the main criminal matter. Interference in all its facets. My client has said he understands and he knows very well that it's a very dangerous and slippery slope to be contemptuous of a court of law, because it will bring rather devastating consequences. He says this in paragraph or page 591.
Yes, before you go to page 5, on page 2, condition number 5, Roman 5.
Yes, my Lord.
I've always wondered. And he offers 200,000. What's the purpose of the 200,000 Namibian dollars that he offers for bail?
The reasonableness, my Lord, of that amount is a serious indication of his commitment to attend the trial, benchmarked against the assets that he has said he has before this honorable court.
If he's going to attend this trial, does it matter whether he gives me $10 or
it doesn't matter, my Lord, at all. What matters is his intention. But it's important for us to also demonstrate. I mean, of course, we have always complained about the requirements of the Act, where you will never know the parameters of what are the requirements. And that's why, my Lord, I've seen the motto of one company here in Namibia, it's better to have it and not need it than to need it and not have it. So it's better to make that proposal, my Lord, as an addition to the requirements that he wants to put forward. He says he wants to attend this trial. He believes he will defeat the case. His state of mind was here, my Lord, for all to see, and especially for the honorable court. But he makes this proposal. That is his tender, my Lord. You can consider it. But I believe that the amount that is tendered, my Lord, in the end, what you must place more emphasis on, your Lordship, is the intention, the undertaking of the witness that or the applicant that he will attend bail, he intends to attend bail, and not the amount of money that wants to put forward. It's an additional factor, my lord, to be considered by the court.
Yeah, no, I'm asking that question because I have, up to now, I still wonder.
Yes.
Is a money issue now what we call a lekker stokkie to,
My lord, you can
to
imagine
entice
if I,
you to sweeten a deal or what?
you can imagine if we had not made this proposal, they will say, you see how tight-fisted they are. They are not serious. They don't even want to forfeit any of their property as an indication of goodwill towards the court. So, my lord, I agree with you. What matters is the intention of the witness. But of course, this is an additional factor that the court can take, that anybody that puts this amount surely must have an intention to attend trial, over and above what I have said. I have seen often that people try to seviate and focus on it as an isolated proposal, but His Lordship, I submit, must consider it in view of all the other proposals and the undertakings and the commitments that he has made while he was before the Honourable Court. If His Lordship, I've addressed all your concerns there, and my Lord, he also, in addition to that, in paragraph 6, Roman letter 6, he says, such other and further practically reasonable conditions that this Honourable Court may deem appropriate. So in addition to, because by now you will have considered all the factors, all the evidence that was before you, you'll have considered whether this witness and that, etc. You can then add such conditions as you deem appropriate, my Lord. We will be able to live with that. That's his proposal before the Honourable Court. So, my Lord, he has also proposed that the interest of justice in this matter demonstrate that he should be given the opportunity to be granted bail and to be admitted before the court. As such, he has then gone back to, and this is why maybe some time was spent on what transpired during his trip to Japan. That evidence was brought forward to the court to enable the court to see, because unfortunately in bail application or bail applications, while the undertakings is there, the court also has to take into consideration the past behavior in order to determine the future. The court is given what we call maybe a crystal ball in ordinary life to say, well, having my crystal ball, having assessed what this person, how this person behaved in the past, is this person likely to do 1, 2, 3? And he says, when this information or the story of the Fishrot broke down, he was in Tokyo, Japan. He was already aware, if he wanted, he was outside the jurisdiction of the court. Of course, he understood the implications on him because, of course, the newspapers, when they breached this information, he was named, he was specifically referenced in those articles, and this was not disputed. He came back to Namibia, he saw some of his co-accused being arrested. He was told that he was also on the line to be arrested. No one ever said, no, for you we are not sure we can give you maybe the ability to be a witness, etc. He was told that we are going to arrest you, but not yet. He then traveled to Johannesburg, he traveled to Harare, he traveled to Cape Town during that time. He never ran away. In fact, there is no evidence that during that time he did anything that is less than commensurate with a mortal citizen who obeys the law at that time. He did not interfere with their investigation. He put evidence before this honorable court that has not been questioned to say, you know, the very same ACC officials, when they were struggling to locate information that could potentially implicate me when they were investigating, they did not call any other person. They called me to direct them where they could find that information. I directed them to that information, and it was helpful towards them. He mentions even the individual that he was speaking to, that was part of the ACC investigation team, and Mr. Kanyangela also confirmed as much. This does not strike me as somebody that, you know, that when you look at his past behavior, there are question marks about it. He has always been very firm that he was subservient, and he understands that the courts of law in Namibia are there for a reason. He respects the court of law. He wants to submit to the court of law. Even when they were threatening to arrest him, he did not go and hide in the basement, you know, of a house that, you know, is undisclosed or somewhere else. Guess where he went? The first thing that he did was to engage legal practitioners. Legal practitioners are officers of the court. Their obligation is to make sure that the administration of justice is upheld. He engaged Kadile Amomo legal practitioners, and he tendered several times that I understand, and I've received phone calls that you are going to arrest me. When can I surrender with my legal practitioners or representatives for that arrest? He did not run away. He did not hide. He made arrangements. Even on the day of his arrest, he says he went to be arrested with his legal practitioners on the day of his arrest. That past behavior, my Lord, weighs very heavily in favor of what he is likely to do in future. And that is the evidence that is before the court. The evidence points hugely in favor that this is a law-abiding person that did not frustrate the administration of justice. And therefore, a person like that qualifies in our submission, my Lord, to be considered favorably for admission into a bail system. He says he's not a danger to anyone. He's not a violent person. He is not a habitual offender. In fact, the only other difficult black spot that he has, he basically pointed it to the Honorable Court that he had a motor vehicle accident and he has been charged arising from that. And he placed that before the Honorable Court as well, for the court to be aware that he was already on bail for something that related not to act of dishonesty or anything, but a motor vehicle collision. So that is something that we submit that the court can take into consideration. He pointed to the court to his age, his place of residence.
Yes, all those issues I've taken note of.
Yes, my Lord.
There are one or two issues in respect of this applicant that I want you to just clarify for me. I don't know when in 2020 he applied for bail in the Match Court. The bail was refused. He appealed to this court. This court confirmed and also refused the bail. The way I've read your head, you are saying at the time that he applied for bail, he was charged with only two or three counts. Yes. But by now, the counts have multiplied to 40. So, and those are
the new facts.
So, is he applying in respect of the new counts? And if that is the case, what I just, you see, there is a judgment of this court. How do I go around that judgment?
Oh, let me help you, my Lord. Mm-hmm. Let's go to paragraph 10 of my heads, where I deal with the background. Because on 2 November, when we were before you, I was specifically put to terms pertaining to his application by my learned friend, Mr. Lutebezi. Are there new facts relating to Mr. Ngipunya? And if so, can you set them out? He then said, after you have put them on record, then we'll indicate our attitude towards those facts. I then pointed out that correspondence was sent to the state, and I deal with this in paragraph 11 of my heads. Correspondence was sent to the state on 1 November 2021 relating to the issue of bringing this application on new facts. We acknowledge that he appeared for bail in 2021. He had only been charged with 3 offenses, being fraud, corruption, and money laundering. It was indicated that this is a bail application on new facts, and I was specifically put to terms to set them out. And I set them out in paragraph 12.1, as I did in the record, that the investigations are now complete, which was not the case in 2021. In 2020, when the applicant brought his initial bail application. If the court finds that, and this was not disputed, so the court can accept that this is an established fact, One fact alone is sufficient, my lord, and I'll come to the authorities when I deal with that. If there is a presence of one fact, it's sufficient to help you to look at the case, not through the snapshot of the previous court when it was considering facts that were applicable before it did that.
No, you see, I'm not looking. What I'm asking is, I'm asking. There is a judgment.
Yes, my lord.
By this court. Do the new fact nullify that judgment automatically?
Right. This is where I come in, my lord. If I take, because if His Lordship is satisfied that I have set out the new facts in paragraph 12, that is the list of facts, 12.1 all the way to 12.
No, that's why I said to you,
yes,
you have indicated the new fact you have said already. And
yes,
I said to you, but there is a judgment. What do I do with that judgment?
Yes,
is it that am I going to override it, or what?
No, my lord, it's not an override as the way I understand the authority said, it's set out in the judgment that I refer to from paragraph 12.12 of our heads, because it deals with that, all those judgments there. That the issue of bringing the application on new facts is only to satisfy the court that the court has jurisdiction. Once that fact is established, the court considers the bail as any other bail, because the court is now dealing with a different case clouded by a new fact which was not there before the previous court. So you are not limited in your consideration of this case by what transpired at the previous court.
Yeah, this is what I'm asking. You see, the offenses, the initial, as you are saying, there were 3. On the basis of those charges that he faced, bail has been refused.
Yes, my lord.
We take it.
Yes, my lord.
Now, your ground of the bringing of the bail is that apart from those 3, there are new ones, counts.
Yes.
So those are the new facts. Now, what happens to the judgment in respect of those existing ones?
Right.
That's all I want to understand.
Right. The new facts, I remember in one case of Judge Parker, if I can take you to paragraph, but I don't want to be too married to my heads. I want to answer your question in such a way that I deal with what is before you. If you look at paragraph 12.15,
Sorry.
and 12.16. Judge Parker dealt with the same thing, and there the only fact that was established is also similar to what we've established, where he found that the period of 2 years and 9 months that the applicant spent in custody, pending the trial after his 3rd unsuccessful bail application, was a new fact. He found that, okay, this is a new fact subsequent to the application. And then he says, since this fact did not exist at the hearing of the 3rd application in November 2011, it was a new fact that was presented to the learned magistrate in the hearing of the 4th application. And then he deals with what, he terms the new fact. The court in paragraph 12.16, we say, the court then concluded that it follows that the period that had elapsed constituted a new fact, and therefore this court has jurisdiction to consider the new fact together with all the other evidence on record. And this is what he also said in that judgment, to consider all the other evidence on record to determine if the applicant has discharged his honors of proof on a balance of probabilities. The way I understand the authorities, they are not saying, even if you have a new fact that has been established, even when you consider this bail, you are still limited to what transpired in the judgment of the other court. So,
no, my issue is not a limitation,
yes,
but it's just a question of the legal principle that once a court has pronounced itself,
yes,
it's functus, and that position remains unless overturned by either on review or on a...
When I look at that, I'm happy, my lord, that does not seem to be applicable in bail application, because that rule is more applicable or akin to when you are dealing with the determination of a fundamental dispute. A bail application is what comes to the court at that time to determine whether this person can.
It's an inquiry.
Yes, my lord, it's just an inquiry. That's why even the formalities of it. So that's why maybe the limitations that will be there or the considerations that will be there, if it's a final determination of a right, it's a whole different. That's why people can bring the application 3, 4, 5 times, as long as they can establish that, no, since the last time I was here and you refused me, there is now this new fact that can assist you to close with jurisdiction to reconsider. Because otherwise, without that new fact, it's used as a sieve to stop people bringing a bail application, for example, every week before the similar court. So you establish the new fact in order to close the court with jurisdiction to reconsider the application. But once the court has opened the door for you after the new fact, then the court is not bound by what or limited by what happened in the previous court. The court considers the bail based on the fact that is before it at that particular day, whether the applicant is.
So the mere fact of acknowledging that it's a new fact,
yes, my lord,
automatically nullifies the other.
Well, one does not want to say nullifies because that is not under consideration. And I'm saying so because I'm looking at this judgment of Shekunja as well, which was setting out all these requirements and detailed and also referred to. It took a snapshot of all this because there was also a consideration, is this a new fact and so on. And Sibeya J there, he took a collection of all these judgments, including the one of Judge Parker that I merely referred to. There were also others that he considered, my lord. If you look at paragraph 12.17, that is Hof J in the case of Noble versus the state in paragraph 21 also had regard to the RSA case of S versus Mpofana, regarding the approach of the court to considering new facts when the court finds that they exist. In considering an application allegedly brought on the strength of new facts, the court's approach is to consider whether there are, in the first instance, new facts, and if they are, reconsider the bail application on such new facts against the background of the old facts.
What does that mean?
Well, that's what the court said, my lord.
What does it mean? You consider it on the background of the old facts?
Yes, my lord. If there are other facts that were there, that were established, that were impeding the court at that time. In this instance, my lord, the entire bail actually was considered on the basis of the new facts. There are no other old facts that were brought to you in terms, because facts can only be introduced by way of evidence. So, in view of the fact that there were no old facts where it was established that this was the fact that was there at that time, this would stop the court, etc., the court can accept that this is a new bail application altogether. Once we have the entrance, establish even a single, fact, we say in this instance we have established more than 7 new facts. That the investigations are completed, we now have access to the disclosure, which we did not have at that time. The list of witnesses have been provided, all those. Then each one of them on its own is sufficient to open the door for us for admission to this application by the Honorable Court. And therefore, my lord, that it says that, but it is also important to argue on the basis that where there is some new matter, the whole application is not open for reconsideration, but only the new factors. I frankly cannot see how this can be done. The very challenge that perhaps you could be grappling with, my lord, the judge here says, I don't see how this can be done. Once the application is entertained, the court should consider all the facts before it, new and old. If the new ones are there, if the old ones have been established, the court considers all the facts that are before it. And on the totality, then come to a conclusion. So, my lord, we will say this judgment provides inspiration that you will be able to consider the application on the totality of the facts that are before you. It follows that I will not myopically concentrate on the new facts alleged. So the judge here says he would not accept that he is only limited to a particular set of facts or not the other. He considered the totality of the evidence that is before him in order to make a determination whether the applicant is entitled to bail. So we say, my lord, there is support for the proposition that we put forward that you are entitled to consider this bail on the facts that are before you and make a determination without restrictions, my lord. In my view, the above dictum should be interpreted to mean that while the new application is not a mere extension of the initial one, the court which entertains the initial application should come to a conclusion after considering whether, viewed in the light of the facts that were placed before it at that time, there are new facts warranting the granting of the bail application. And we submit, my lord, like in Shekunja matter, that if you are guided by those principles, you have the ability and the competence, my lord, to decide this application based on the facts that are before you today, whether my client is entitled to bail. Mm-hmm. Yes, we say the facts were not controverted. They were not contradicted because facts are brought by way of evidence. They were not disputed. They are, not at all. In fact, the state did not, as they had said when they put me to terms, if you look at the record, they had said they would indicate their attitude. Once we put and established those new facts, their attitude was the grounds for the opposition of the bail. It was not a crown that there are no new facts that have been established. So the door is wide open, my lord, for you to consider this bail application in the manner that we have proposed before the Honorable Court. Of course, if there are objections, we'll ask them to point us to the record because we have the record here. At least that one, we have the record, unlike the other ones where the record has not found a way to us for one or other reasons. But we don't take issues with small things. We are focused on the big fish here, my lord. So, my lord, as we say, when I look at the evidence, it focused hugely. I mean, almost 90% of the testimony, or 95% of the testimony of the state did not question whether my client is a suitable person for admission to bail. On the facts that my client, has procured a passport, he intends to run away. He was in the witness box. Nothing of the sort. The only smallest shred of evidence that was tried to be raised with my client pertained to the statement of Kamano. My lord, the statement of Kamano is Z23. Mm-hmm. And there were allegations that were being preferred by the state. Now, let's see how they were dealt with, because they were dealt with under cross-examination when he was available. If we find that, based on my submissions, the state accepted my client's explanation, my lord, this matter comes to rest of the statement of Kamano.
Sorry, let me understand what the submission is.
Yes, my lord, I'm saying there was no statement that was made that my client has attempted to jump over the prison fence to run away. I'm just giving you one example.
And he hanged from the...
And he was hanging from the... No, my lord, I don't want to get into trouble with other legal practitioners. But all I'm saying, my lord, is that Mike has never tried to put excessive oil on his body in order to slip through the pipe. This is the man that was sentenced, and he stayed there. He has never been accused of anything else. He stayed in jail. He has not made any attempts for anything. There is nothing untoward that has been alleged against Mike, except on one aspect, and I will deal with that. Mm-hmm. He has not been called to say that there was a man with a, there was nothing actually that the state controverted Mike when he was, in his testimony when he was here, that he is a flight risk. Of course, when a legal practitioner says you are a flight risk, that's a conclusion that only the court can make.
And when a legal practitioner says you are not a flight risk?
Yes, my lord. That is only a conclusion. It's
also a conclusion.
Yes, it's also the other way.
Yeah.
That's why I said, my lord, judge me not on my intentions. Judge my client not on his intentions, judge him on his actions. We say the pattern of what he did from the moment that he knew, not even prior to his arrest, the moment that he knew what was coming towards him. Because my client was here, nobody has said that my client is a stupid person. He's very intelligent. So he knew the consequences when he read the story. He knew the consequences.
When is it that he was in Japan?
It was in 2019, my lord.
When?
In November. October, November, when the story broke, he was in Japan. He also traveled extensively around the region in South Africa.
No, why I'm asking when is, I have a reason. That's why.
Yes, my lord.
Yeah.
So this man has never tried to run away. I mean, why would somebody, if you are already in Japan...
No, on the runaway,
yes, my
proceed.
lord.
I've accepted...
Interference. None of them whatsoever.
That's why you'll have to...
Yes, that's why I was coming to that.
That's why you'll have to disabuse me.
Yes, my lord. Let me take you to the record, my lord.
Yes.
Page 553. And I've also dealt with it.
553 of what?
553 of the transcribed record.
Just hold on.
I believe in our heads we deal with that. Maybe let me just take you previously to the heads, not bother you extensively, my lord. Is that quotation? Our heads, my lord, if you look at paragraph 136.
Yes.
Paragraph 135, that's where we deal with where he states the state's reliance on Jose Ramon Camano Canosa. JRCC refers to that individual. That he conducted him during November 2019 in order to demonstrate that he is slightly likely to intervene. Gepunya responded that he was flabbergasted as to how he would be considered a possible obstruction of the course of justice based on that. And he says this in paragraph 500, page 553. And let me start because there are two instances that are alleged by Canosa of his engagement with Mike. There is the engagement pertaining to the signing of the agreement. And then there is the engagement from prison that the state seems to be trying to get some traction and mileage on. But either way, I'm saying nothing turns on both. But let me stress first the statement, the engagement prior to, around November, prior to Mike's arrest. He says, the first time he sent these agreements to be signed to Jose Ramon was in 2017. Page 553, my lord, line 19. And then it goes on from there, I'll deal with it. If His Lordship wants the full bouquet of all this,
500?
dealing with this, it starts 553. But His Lordship can also read the record from page 448. That's where he deals with the essence of Jose Ramon's statement. I submit from 548 to 560. So it will allay the questions or observations that His Lordship has demonstrated with me at the moment.
Page 548 to?
548 to 560. Under cross-examination, that's when he deals with the essence of Jose Ramon's statement. That's why he tells Mr. Lutebezi that he first met this individual in 2010. It's not true that they met in 2014. That's in page 548. He even says, I have pictures of this guy and his COO that we took some time in 2011. Page 549. And he was not interrogated or canvassed that he is either lying or he is inventing new information. This was accepted by the cross-examiner.
When was he appointed as CEO?
In 2014, he was seconded. 2016, he was confirmed.
Yes?
Yes, my lord. So I'm saying that part will answer quite a lot of the question marks that His Lordship may have. But for purposes of my time, I'm mindful that I'm running the clock. Let me take you to page 553 of that record. I'm not leaving the other parts. I'm saying from page 548 to 560. You'll get all the questions relating to this testimony. But now I'm focusing specifically to the questions of His Lordship.
Yes.
He says, because the challenge was that the only reason why he sent this agreement to be sent to, he sent this agreement to Jose Ramon was to try maybe to do some fancy footwork about what was coming. He says, no. In fact, what Jose Ramon has not told you, Mr. Lutebezi, and this is a man of, that I say, a witness that comes forth and gives you more than what is, what you have asked, but you take the sequence, is someone that needs to be believed. He says in 2017, And my lord, I believe that will be line 14, page 553.
Yes.
He says in 2017, when we concluded the agreement between Wanyamba Investment Trust and Skeleton Coast Trawling and Deep Ocean, it was discussed with Mr. Ramon, and we agreed that he will, or GIT will then send the consultancy agreement to them for signature, which was sent, and it was not signed. So he gives a background of these consultancy agreements when they were sent. He said that is 2017. If you look at around line 26, he says, so I sent the agreement again in 2018. To say you can have this agreement signed because our auditors are asking for this agreement. He has testified before this court that around this time is the time when normally auditors would ask about all these agreements, and that's why he was signing this in order to pass the auditing hurdle that was presented by his auditors. He was told,
why his auditors here?
I beg your pardon?
Why his auditors?
Well, we don't have the evidence here of the auditors. It was not explored under cross-examination. Okay. But he gives the reason why he sent these agreements in the first place. It was not to run away from the alleged misconduct. He said, I sent this agreement to Jose because our auditors were saying these agreements need to be signed. It was in the spirit, the way I understand and interpret that testimony, it was in the spirit of good corporate governance. He was not told that he is lying. He was not told that that is incorrect or his memory is. The state, advocate accepted this. He said, you can have this agreement signed because our auditors are asking for this agreement. Then he assured, no, I'm just waiting for Miguel to come so that he can sign. And then we sent it again in November 2019 for him to sign. I mean to have it signed. And still I'm only getting obviously the events that happened thereafter. So he says the agreement was never signed because there was some hiding because of Fishrot or the impending scandal. It was sent because it was an auditing requirement from his auditors. And this was accepted. How then does the state jump back and say, listen, when you send this, you were actually avoiding the consequences of your criminal activities. They failed to take that with the witness here, and I don't understand why this court should be bothered with. It must be accepted as a fact. Because he was not challenged. It's unfair for the court, for the witness to be brought here under oath to testify and not being challenged. And then in argument, the legal practitioner comes and says, no, when you said this, you were not telling the truth, you were actually lying. The true intention was the other one. When you failed to take that with the witness while he was still in cross-examination. So, His Lordship, you can rest assured that the reason why the agreements were sent had nothing to do with the case of the prosecutors or the state. And that matter is settled. Now, let's continue, my lord. Mm-hmm. He deals with this statement of Jose Ramon again in paragraph, the same page 554, towards the bottom of that page, from line 22, where this guy says, basically what he did was that the statement was read to him, that Mr. Ngepunya called me about a consultancy he had wanted to sign for consultancy. He ran that to us, and a copy of the agreement is attached. If you go to page 265 of the bundle, there was some exchange between the cross-examiner there, etc. I want to take you, my lord, immediately to that this agreement was sent for something for safety, as Jose Ramon, perhaps, although that testimony is hearsay evidence, we can deal with it. If you go to page 55 towards the bottom, line number 30 of that page, he was asked about that. Ngepunya told me that this agreement would offer him and Novanam a form of safety. Quite what that safety is. What is this safety? It was never explored by the prosecutors. The type of safety that we are talking about. Is it safety from wild dogs? What is the safety from? Now we are left to a situation where we have to guess, because the statement was left hanging. What does the court have to make a statement like this? But nonetheless, my client answered. He says, yes, I see that. If you look at the the middle of that page 556. He says, yes, I just see that, and I still stand by my statement I made about the reason that Jose Ramon will go to that length. But if anything in this agreement can be taken for what it is, I mean for this statement is what Jose Ramon is saying in paragraph 40, where he's conceding that this was for services that were rendered by us to those companies. And also the other aspect coming out of that, if you look in paragraph 42, he says Ngepunya sent the draft agreement to me by email. I cannot recall the exact date when I received it. I told him that I would forward the agreement to Novanam to dealers. And it goes on and on, my lord, to the next page. Now, Mike says on the next page, 557, why would somebody that knows that there was no consultancy services that was provided undertake to actually request his boss to sign the agreement? He says this is strange. Now, if we continue, where he now deals with the issue of interference that is so relied upon by our learned friends, there were issues of payments that were dealt with in page 567 to 569. But in the end, what is interesting, my lord, is what happens towards the end of that cross-examination. Where Mike specifically now deals with this issue of alleged interference. You can just give me a moment, my lord. It will be on page 591. He once again, in the top middle of that paragraph, of that page, I believe it will be line 5. He says, to the question, yes, so you confirm that you did in fact inform him to do so in November 2019. Mike says, yes, I have. I have informed him to do so in 2017. He goes back to again, November 2017, I did so, 2018 and 2019. Because that is the time that we carry out our audit for the GIP. I mean, Wanyamba Investment Trust, I believe that is a typo, my lord. And I just also want, while you are there, to indicate to you that not only did I send him the consultancy agreement, I also sent him the last invoices that were paid by Novanam in November. So those invoices were sent to him also together with the consultancy agreement. So, and he was asked, then when you send this consultancy agreement at that stage, were you not in custody? He said, no, I was not in custody. Now, what is more interesting is what comes out after that. So I put it to you that there is a likelihood of you interfering with witnesses if you are released. Because this was the foundation that they were trying to build of Jose Ramon statement. What does Mike say? He says, that is not true because I have never tried to interfere with any witness since my incarceration. Of course, the consultancy agreement and the communication you are referring to, it was before the allegations against me, and I was still a member of the public. Taking into consideration that in November, Mike was still...
You see, this is where now I ask you exactly the question. When was this?
It was in November 2019. Yes.
When did he travel to Japan, Tokyo?
Yes, it was around November, my lord.
Yes.
Yes.
And on your own issue, you said he knew already that he's a suspect. He's been told that he'll be arrested.
Yeah, himself.
Yes.
In
So he
respect of
knew.
yes, in respect of the quotas.
He knew he's a suspect. So to say that, that's why I'm saying.
Let me help you, my lord, because
Yes.
we need to clarify one, yes, and see what I can give clarity. When the scandal broke in the first place, it never was about him carrying out consultancy services. And it's very important, my Lord, to draw a distinction.
No. What I'm saying, I am not referring to what he was doing.
Yes, my Lord.
You see, it's the submission that at this time, when he was doing all this, he was not even a suspect. And this is what I'm saying. If he traveled to Japan in October, November, then your submission cannot be correct. Because on your own submission, you are saying when he traveled to October, he broke out while he's in Japan, and he knew that he is a suspect, he is to be arrested.
Yes.
So therefore, if he knows he has to be arrested, he's a suspect, he knows.
Yes, but for what, my Lord? That is important.
Yes, with regard to this matter.
Yes, my Lord, it's very important.
Yeah.
Let me try to draw a distinction because I think it will be helpful, my Lord. The arrest was in regard to the fishing quotas.
And no one is involved in the fishing quotas.
Yes, my Lord. The fishing quotas only. Not insofar as his work as a consultant. At all times, although the state is trying to put this together.
No, the issue here.
Yes.
It's not about, remember, these agreements are tied to the fishing quotas. They are not tied to other consultancy services.
My Lord, I beg to differ a little bit.
That's a state's case.
Yes, my Lord, that's
a state's case.
That is their case, my Lord.
Yeah.
There are agreements for the catching of the fish, the quotas. The work that he was sending the invoices for had nothing to do with the catching of the fish. He was providing...
No, that's his version.
Yes, but his version is that he was providing...
And you see, I don't want to be dragged into the issue of having to make a finding on some of those issues.
Yes, my Lord,
because I don't want to go there.
Yes, my Lord.
All that I'm saying, what the state is saying is, we have evidence, and we will need evidence that he knew, and all that, you see, all that I'm trying to say, that he knew,
yes, my Lord,
that he's a suspect, and he attempted. That's all. And you were doing well to try and, yeah.
So I was doing well, I'm no longer doing well. Let me...
sorry?
But Lord, you are saying I was doing well, so
you were arguing
yes.
to try and disabuse me. You were trying to argue. You see, all that I was saying is, where I got confused is when you come and make the submission and say, at that time, he was not even aware, whereas you have made other submissions already.
All right, let me make other submissions that are even more helpful, my Lord.
Yes.
The same page. Because I said we have to judge him by what he also says. He says, as of now, that is from paragraph, I believe it's paragraph 26. And, or line 26, my Lord, my apology, not paragraph. And of course, now that I'm here applying to the Honorable Court, I have indicated in my prayers that one of the conditions attached should be that I don't interfere with any of the witnesses. Now, you have a statement of somebody that will come, to say something at the trial, who may not even say that thing again. You also have a witness that is under oath before you, so that you have to make a determination. When this person says this, should I believe that he was meaning what he was saying, etc. When you weigh the evidence and the testimony of Mike on a bigger scale, it will always be heavier because he was before the court and he answered questions to the fullest. And therefore, I believe, my Lord, and I submit that you can rely on his undertaking as he stipulates them in this line.
Yes, Mr. Patella, I do. It's as I'm saying, I want you to disabuse me on some of the issues that I have.
Allow me, my Lord, then to continue.
No, before you continue. Remember, he is denying also that ever since he has been in prison, he has not made contact with him.
Yes.
But Canosa says, once he's in prison, he contacted him twice from a cell phone that does not display a number.
Yes.
He doesn't deal with those issues.
Okay, let's see whether he doesn't. Let's read that line, my Lord, of maybe we will then reach a conclusion that I can then be able to make submissions. Yeah. Because that's what Canosa says. But you have a witness that is before you. You evaluate this witness. Let's see what this witness says and the questions that were put before him. He says...
Where are you?
I'm still on page 591. I'm sitting there, my Lord.
Okay.
Yes. He says... He is still committed to the promise that, because he knows that, like anyone in this country, he accepts the Constitution in the courts, whatever it has been put forward to, my lord, he would never want to be in contempt of the court. Page 592. He would never want to be in contempt of court because he knows the repercussions that come with that. He knows them. So he says, I come to you as I am. I'm a new man. I'm before you, judge, before this honorable court. This is my undertaking. He is a witness of the court. He says this under oath.
No, I hear you.
Yes,
He said that, but all that I'm asking is, if he says that, why doesn't he tell me what he deals with the allegations that he contacted from prison, not while he's in Japan,
Yes.
not while he's in Oshakati, but from prison. He contacted Canosa on 2 occasions
Yes.
from undisclosed numbers. And an emissary was sent to Canosa.
Yes. My lord, the way I understand...
So, if an honest person will open up on all these issues.
My lord, I believe he was open because I was reading a part of his statement earlier where he says he would never interfere with the witnesses.
Yes, I'm saying that's what he is saying. Now I'm saying there is this testimony that he did speak to a potential witness from prison.
My lord, that testimony, if you look at it in the bigger scheme of
Well,
things,
you see, and this is what I'm saying. I don't want to be dragged into whether to find that indeed occur. Or all that I'm saying is, the state is saying it will come and lead that evidence.
yes, my lord, the difficulty that was there is that, and I'm saying all this, my lord, to point to you at the end, because it's a very important consideration, my lord.
Yeah.
Yes.
And it's actually what is bothering me.
Yes, my lord.
I am upfront and straightforward with you.
Yes, my lord.
That's one issue that's bothering.
I was forewarned, my lord, that
Yes.
maybe that could be the line of questioning by my intelligence, my lord.
Yeah.
He says,
No, in court we don't have intelligence because we are in public. Only things that are done in secret, that's why you have intelligence. In
Yes,
court we are in public, everybody hears, they know. Yeah.
no, that is actionable intelligence, my lord, that I received, that perhaps I should be prepared for this difficult part of the... And if you go, my lord, if you go towards the bottom of that page, 592,
Yeah.
he says, I would never have done that. So I'm just trying to show that even at the time that, the only admission that Mike makes is that he contacted him in November prior to his arrest. Any further contacts that are alleged, they were clearly disputed in his, and there was no determination, my lord, that, or the question that Mike is not telling the truth or he is incorrect. He says, I have never interfered with any witnesses. And that statement we have also quoted, that's the one that we have quoted in our heads of arguments, my lord, because we believe that this is decisive of the question that is before his lordship. He was here before his lordship. He was asked the same question. And we deal with that in paragraph 136 of our heads of arguments. He says, this is not true because I have never tried to interfere with any witnesses since my incarceration. Was he told that he is lying? Was he challenged by the state? He was not. He said this under oath here. So at the end, my lord, there is the hearsay statement of Jose Ramon and the testimony, but there is a witness that gave you primary facts. Because we can then accept that as a fact. He denied any interference whatsoever. And he then dealt with the consultancy agreement, which he says that was before, all this. But he says, I can never be tempted, and I'm still committed to that promise. And at the bottom, at the middle of that paragraph, I'm still committed to that promise because...
Can I, this thing is bothering me. I must be frank with you. It's bothering me. When somebody says, when one is in prison, one is free in the public. This is a potential witness. This is a person who has made statements. The person who's in prison still goes to him and says, give me money, assist me. What do I do of those issues?
My Lord, in final tilt to this, if it may be necessary, in May 2021, or on 6th of May 2021, there was the disclosure by the state, including of the witnesses, where now everyone knows who are the witnesses that are going to appear before the court. And I believe, my Lord, in the view of all that I have submitted, without abandoning the arguments that I have put forward, my Lord, this also presents a new reality that if there was any interference after that period that was alleged, where he knows, we now know, because the list of the state of the witnesses are also enlisted formally in a proper pre-trial order. That would be an additional fact that His Lordship can consider. And we say, my Lord, one of the reasons is that, and insofar as the issue of money is concerned, my Lord, regrettably this issue was not raised with him while he was on the stand. Whether the money issue, the question that maybe would come into the court's mind is that in normal human relations, and maybe we have to let's look at Jose Ramon, normal human relations. Somebody who is not my friend borrows money, 100,000. I give him 50,000. That please go and take care of your legal bills. That's what it shows that the way I see it, my Lord, and I'm being honest, now I'm trying to factor in human relations. It's not interference when you borrow money from a friend.
No, it's not you see, you know what is unfortunate in this thing?
Yes. I'm trying to deal with that, my Lord, and the limitations of the facts that
this
I
is
have
a
before.
person you've met once or twice. It's a person, it's a customer. I don't know whether I'm pitching the whole bar very high.
Very high, my Lord, yes.
Because of our...
Yes, my Lord.
I would never go to a client and borrow money from a client. Never. Now, what is the message that's being sent out?
The message,
isn't there an obligation, a duty, that you owe something?
No, my Lord, I don't know.
Because I was even wondering that he gives a 50,000.
Yes. My Lord, I believe if Jose Ramon was coerced, because there is this lingering obligation, I think he would have said so.
No, you see, and where I'm bringing it in is simply on the issue of the possible interference. That's where because this is now whilst he's in jail.
Yes.
And this is why I'm bringing it up.
I'm trying to answer it, my Lord, assuming that is because, remember, I start from the premise that my client says he has never interfered. And I believe that
this is what I'm saying.
Yes.
Some of the issues, you listen to what a person says, you look at the facts and the circumstances surrounding it to evaluate whether what he says can be sustained objectively.
The borrowing of money is like, for example, he has said one of the witnesses is his brother. The support dependency relationship that they have, I do not know. But interference, the way I see it, is that let's do actions that sabotage the state's case. But if somebody borrows money, it may not be what any other person would do. But that cannot automatically be construed as, because it's limited, interaction was limited. If we accept it, which I said the court should not accept because it was denied, but assuming the court wants to accept it, even that interaction was specific because it was limited to the borrowing of money or whatever. I don't know whether it was borrowing, but the acquisition of money. And Jose Ramon, unfortunately, in his statement, he doesn't elaborate on that. So at the end, the court can also not give Jose Ramon's statement much more credit than it deserves.
I'm giving it no credit at all. No, remember what I've said from the beginning. I am not here to make findings. All that I'm saying is I am looking at what the state says.
Yes,
what is the evidence that it has? That's all I'm looking at.
Of course, when I say the court should not give it, I'm not personalizing it, my Lord. I'm just saying the way that has to be given to that. Yes.
What I want you to eliminate
yes, my Lord,
is this thing that I have to make a finding.
No, my
For
lord.
me, if you believe, you have to make a finding to believe.
No, I believe, my lord, I submit that, my lord, you can disregard that portion because
Okay.
the weightier evidence that is before you, that was not controverted, is that there was a denial that there was interference. But even if the court, for some reason, that, may go beyond my submission, if the court, for some reason, still has that lingering question, then we have to put that interaction in its context, the interaction itself. It was really limited to borrowing money or obtaining money. It was not that, hide those files, do this to these files and so on, because that would cause interference with the state's case. The state case is not that they have access or they own the funds of Jose Ramon. That is not part of the charges nor any. So when we say interference, we mean the case. What is the case? The case is that the relationship as it existed between them was symbiotically corrupt. That is the case. It's not that, the money that you have in your account or your car or your suit or this belongs or somehow is linked to that. If that was the case, then that's something else. So I don't believe that the court should go into that because the exchange of money, because we don't understand human relations, I'm saying, as you have said, my lord, that I would not do this. I don't know what level they operate at, but that is between, but is that the state case, that this man's monies belong to the state? That is not the case, and therefore I say it goes beyond the ambit of what we are dealing here. The ambit of the case is that from 2014 or whatever, 20 years, to 2019, you had this symbiotically improper relationship. And they have all the facts here, so there is no indication that the borrowing of money itself somehow interferes with, because it must interfere with the case as it before the court. And I submit, my lord, that there is no such case before the court. Of course, it's something that morally may raise questions, but...
Yes. Actually, as I said to you, yes, the issue of that, I did not raise it to see the reason exactly why the money was given on.
Yes,
all that I raised it with you.
In order for me to address it?
No, apart from address, to show you the concerns that I have.
Yes,
and the concern is that although he denies,
yes,
he denies having made contact from the time.
Yes.
He denies having made contact from the time that he was in prison.
Yes,
there is this testimony.
Yes, my lord.
That's all I...
Oh, yes, my lord.
Yeah.
I believe now we have addressed it to say, my lord, the case does not extend to this man's bank accounts, the case of the state. But over and above that, something more was made during the testimony of Mr. Kanyangela.
Can I, before you proceed, because I think we have closed that part of...
Yes, my lord. I'm glad if I have done so, my lord. Yeah. Is it successful? Or?
I don't know. Why? Remember, I indicated when Mr. Sony was unfortunately not there, but when you came to see me on Monday and Tuesday, I indicated that I want to finish hearing submissions.
Yes, my lord.
I see we are at 3:30. Maybe I would just ask for a 10 to 15 minutes adjournment so that we can make arrangements with the prison officers, because I'm going to continue until we are finished, even if you have to be sitting until 10 o'clock.
As a precision.
So if we can take a 15 minutes adjournment so that you try and see whether you can contact the prison officers, so that we make arrangements for the applicants to arrive late at the... But by whatever time we finish, don't give them an hour, don't give them a time. Just tell them that whenever we finish, they'll come.
Lord, I'm sure Mr. Lutebet is...
No, I'm putting it on you. Don't kick the ball. I don't want through passes.
All right, my Lord.
There's no goal to score.
I'm very reluctant to communicate with law enforcement officers, but in view of the directive of the court, my Lord, I will try to...
Yeah, if you can just try and
communicate with my learned friends accordingly. That's a precision, my Lord.
All right, the court will then adjourn.
All right.
Wait, no.
I gave you electronically. That's why you were suspect of leaking. That's why you were in November. You were a suspect. Let me call it. Guys,
Look, the basic, please call man.
I'm putting the officer in charge on speaker. Can you be here? I'm calling you.
Stop to visit.
Yeah? Yeah? I'm putting one speaker, so I want you to know that I'm calling you.
If he doesn't have any